both the Provincial Commander General Boysen as well as the SVC team that was supposed to be reporting to him.
Thank you very much. Then you deal in B with predicate offences.
That is correct, Chairperson. Predicate offences. General Boysen took part actively as a participant in the commission of the offences by directly or indirectly supplying information to the tracing team of the whereabouts of the suspect. For example, when Magojela was traced, he provided information relating to his movement out of Pietermaritzburg and the vehicle that he was using. We will elaborate more in the prosecution memo.
Yes, is this what we dealt with extensively 3 days ago?
That is correct, Chairperson.
All right, carry on.
I have received a full briefing from the prosecution team and perused the documents that they supplied me. I am convinced that they make a good case for Boysen to be charged and recommend that the racketeering certificates be authorized. In relation to your interventions, I understand...
So just stop here. What do you mean, your interventions?
It would refer to the role that the NDPB was playing to try and understand and to try and to question us and to
you deal with it after the comma.
Yes.
You say, I understand it, yeah.
In relation to your intervention, I do refer to Advocate Chauke's interventions in court. When counsel who represented the then acting NDPP made wrong concessions in court during argument, I'm informed that Advocate Chauke then approached counsel and corrected him. The court adjourned after the applicant's response. Counsel indicated that the corrections will be made after the adjournment. And the court then adjourned without affording counsel the opportunity to rectify the concessions made.
So what's this referring to?
This is referring to the time when Advocate Lawrence Hodes was arguing in court. When my understanding was when the court asked we do not have any statements linking the accused to the case. Then when he started, he said, yes. When you say yes, his view was that, well, I hear what you are saying. Then he would continue to explain. But when you start your response with yes, then it gives the impression that you agree with the court that there is no evidence linking General Boysen to the case. Because his explanation to us was when he responded in the affirmative to what the court was asking him, he was saying, yes, I follow. Then he would then continue to give an explanation. But then the court understood that to mean, yes, there is no evidence linking General Boysen with the case.
Well, we went through that yesterday. We saw in the end where it's explicit that the advocate said that there is evidence linking General Boysen. But here I'm more focused in Advocate Chauke.
Oh, okay.
You remember that he is charged in these proceedings, among others, for the role he played in the opposition to the review that was brought by General Boysen. Now, what is puzzling here is that there's a man sitting in court. There's an advocate who's making a wrong concession. One of the staff from the NPA goes to correct them. I don't understand why he then gets charged. It seems to be a good thing for the NPA.
In fact, it's making the NPA look good. He's preventing the NPA from making a mistake.
Yes.
It's supposed to be applauded instead of it being looked at in a negative connotation.
Yes. And it's unclear what they say he should have done. He's sitting in court. There's an argument. A wrong concession is made. What is he expected to do?
In fact, it was very brave of him, to approach. He couldn't fold his arms and let a wrong concession be made.
Yes.
It was proper of him to have done what he did.
Yes. Thank you. Then we've dealt with the statements from 429 to 432. Unless there's something you feel has been left out, we can move on to the next era, which is the era of Advocate Abrahams.
That is correct, Chair. We can move on.
Ngcukaitobi, just out of interest, you'll probably remember the authority or the pronouncement by the court regarding concessions made by counsel in court. You may just ask your junior to search for that constitutional court authority,
Yes.
which may be of assistance at the later stage.
Thank you, Madam Chair. Perhaps, Advocate Maema, let me test your legal knowledge. Is a legal concession, is a legal concession made by counsel in court binding on the client?
No, it is not.
Right, thank you. It seems your legal knowledge is excellent. Yes.
Are you the examiner now?
He's already passed his exams. Thank you, Madam Chair. Actually, we've noted it. Now, from section Roman figure 3, paragraph 433, you deal with the Abraham's authorization, but you first deal with the transition from 433, which is largely common cause. We know the circumstances in which Advocate Nxasa vacated office.
That is correct.
It was through litigation, and there's a reported judgment of the Constitutional Court. And the result was that Advocate Abrahams replaced him on the 18th of June 2015. That's all common cause, unless you want to comment on that.
That is common cause.
Yes. And then, what then happened when Advocate Abrahams came into the scene in relation to the prosecution of this case?
Chairperson, on his resumption of office, then we then, because we believe that we had a case, we also made a presentation to him. We also furnished him with the dockets on his request, and we waited, and it was, I think it was in 2016.
Yes, but did he ask you to make those? Did he ask for a briefing on the case? How did it happen practically?
Oh yes. No. When he came to office, he didn't only ask for a briefing. Because at that stage we were based in the DPP office in South Gauteng. Then he directed that we should be based at national office, at his office, so that we can deal not only with this matter, but with other challenging matters that he had in his office.
So he took your entire team from Johannesburg to Pretoria?
That is correct. He took some of the team members, myself and Advocate Matenjwa. We then worked from head office.
You see, Advocate Chauke is also charged in these proceedings for an attempt to have these charges against Keitoman reinstated during the era of Advocate Abrahams.
That is correct, Chair.
Yes. Is that factually true?
It's factually untrue. It is actually the prosecution team that was trying to have the charges against General Poison reinstated, because we felt, we were convinced that it is the right thing to do.
What role did he play, Advocate Chauke?
Nothing at all. Because at that stage then we were at head office. There was no need for him to have any role, because then we could brief the national director directly. Some of the instances he'll just walk into your office. So we had direct access to the national director.
Yes. So carry on. So he's asking for a briefing, and then what happens?
He asked for a briefing. We gave him the briefing. We waited and waited and waited, and then one of the Mondays when I returned from a party that I was dealing with in the Northwest, Advocate Matenjo then informed me that the racketeering authorizations were signed.
Well, let's just go through it as in a sequence, because you deal with it sequentially from paragraph 434.
Chairperson, on 17 August 2014,
Sorry to interrupt. Before he reads paragraph 434. At paragraph 433, he refers to Mr. Ngasana as advocate. Okay, is it a typo, an error, or does it need to be corrected, or at that time Ngasana has been admitted as an advocate?
Chairperson, Mr. Ngasana was an attorney, but ordinarily, because his predecessors were advocates, everybody just refers to him as Advocate Ngasana. But he is Mr. Ngasana, he's an admitted attorney.
Okay, so
Remember, I asked you the question yesterday, and you referred to him. You said he's not an advocate, he's an attorney.
That is correct.
And I see in several paragraphs you refer to him as an advocate, and I get confused. There's clearly a difference in that, Maema.
There is clearly a difference, but all of us just fall into the same trap of referring to anybody at head office as advocate when there are those that are rightly there in their capacity as attorneys.
okay, well, your statement refers throughout actually to Advocate Ngasana. I personally always thought he was Advocate Ngasana, but anyway, until these proceedings.
No, he is proudly an admitted attorney, Mr. Ngasana.
Okay, well, that will have to be corrected. That was the question asked
Yes.
by Advocate Baloy Merit. Is that a typo, or does it need to be
It is a
corrected?
typo. It is a typo, and I apologize. I didn't pick it up. Chairperson, I was focusing more on the content rather than on the
So you will refer to him as Mr.
Ngasana. That is correct, Chairperson.
Thank you. So you were at 434.
Mr. Ngasana vacated office in May 2015. Advocate Abrams was appointed on 18 June 2015. Paragraph 434. On 17 August 2015, I prepared another prosecution memorandum with a draft indictment that was to accompany the new poker authorizations that were prepared by Advocate Noko on 18 August against General Boysen and other accused. Chairperson, when I say prepared by Advocate Noko, I would do the typing and the preparation, and then I will present them to the DPP for consideration.
Yes, I mean, we know now from the evidence of Advocate Noko that at this stage she says she was fully familiar with the case and she was happy to endorse the motivation for the issuance of fresh racketeering charges.
That is correct, Chairperson. Yes. At 435, on 27 August, the prosecution team made a presentation to guide Advocate Abrams through the evidence. The presentation document, which is dated 9 July 2015, is attached here to as Annex GSM 87.
Yes, let's just look at that. It is at 1A840.
That is correct, Chairperson.
Yes, there are those names there. Who are those people?
Chairperson, the names Adv Sello Maema, Adv Kulegani Matenjwa, Adv Jabulani Mlojwa Advocate Mahlubi Ntlakaza, Advocate Matsidiso Muleko, Advocate Pumeza Fuchani. Those were the members of the prosecution team. And on the side there, I wrote Advocate Moipone Noku, the DPP in KZN, who was at the time the supervisor of the team.
Yes. So it's dated 9 July. So is that when it was drafted versus the 27th of August 2015, which is where you say it was presented? So I'm not sure. Yes, just clarify the dates.
Chairperson, my recollection was that it was presented on the 9th of July 2015.
Yes, I mean, your statement says it was presented on the 27th of August.
It would have been presented on more than one occasion, but the first time that it was presented was 9 July 2015.
Okay, so
Was the presentation not made on 27 August 2015?
There was also a presentation made on 27. The same presentation was also made. Chairperson, what we do is we'll do a presentation, and when there are issues that we have to deal with, we will return with the same presentation and then deal with the issues that were raised in the presentation.
Let me understand this. The presentation document was dated 9 July.
That is correct. The
2015.
slide presentation.
Yes. It's dated 9 July. And the actual presentation was made on 27 August 2015.
Chairperson, we presented on the 9th of July as well as the 27th of August 2015.
When did you prepare that presentation?
The one for 9 July. This very presentation.
Were there two slides prepared?
Chairperson, we
Or
would
separate presentation prepared?
It was the same slide. So the same slide, Chairperson, that we presented on 9 July, we also presented on 27 August. Except that on 27 August, we dealt with the issues that were raised in the July presentation.
You see, what is confusing to me is that this presentation is dated 9 July, as if it was made on the 9th of July 2015, the way I read the second sentence. And then the first sentence, it says the presentation was made on 27 August. That's where I get confused. But just explain to us that paragraph 435. Maybe you can read it before and then just
Yes.
explain to us.
On 27 August, the prosecution team made a presentation to guide Advocate Abrams through the evidence. The presentation document, which is dated 9 July, is attached here to SGSM 87. He also handed Advocate Noko's first application for authorization and my original prosecution memorandum to Advocate Abrams.
So that's the point, isn't it? It seems that what happened is that the presentation itself was drafted on the 9th of July 2015, but the actual talking to it was on the 27th of August 2015.
Chairperson, I will have to check, but my
Well, what do you need to check?
I just wanted to go to my notes
Well, go to your notes. There's no.
and see if. Chairperson, on this note, I think it's even now it's getting more confusing. Presentation NDPP 7 April 2014. 60
But
slides.
that's irrelevant to
Yes.
Advocate Abrahams. What's relevant because Advocate Abrahams was not in office by then.
This is the presentation to Mr. Ngasana.
Yes, no, but this is about the presentation to Advocate Abrahams that we're dealing with.
You're talking about representation 2015. Let me just see. This book ends at 14 June 2015. Let's see if I can get the book thereafter. What is a later book? Book. The only book that could help me is this one, but my notes on this book ends on the 14th of June.
But could I probably assist
so
you? If you go to GSM 88, I mean, it seems clear that the presentation was on the 27th of August, because if you look at the next annexure, you give further information that was requested.
On GSM 88?
Yes. So if you look at GSM 88, which is at page 18899.
I'm there, Chair.
Yes. There it's under the term lines. Notes and comments after the briefing session to the National Director of Public Prosecution on 27 August 2015.
Yes, no, it makes it clear.
Yes.
There.
All right. So can we that go back then? Because I think you ended up confusing yourself unnecessarily. Yes.
And confusing us.
In the process. My apologies, Chairperson.
Yeah, but it is now clear.
It is clear.
Thank you for that.
Yes.
Thank you very much. Now, I wanted to take you to the actual presentation, which is at 1A840.
That is correct?
Yes.
I am there, Chairperson.
And then we were still at the front page asking who those people are, and you've explained who they are.
That is correct.
Now, is there anything in the presentation, I mean, you've spoken extensively about these charges, but is there anything in the presentation that you wish to emphasize that you told Advocate Abrahams?
Chairperson, we went through the entire presentation just as is. On all the dockets on the incidents, we will freeze it there and then deal with it. And yes, we went through the presentation as it is.
And what was his attitude?
His attitude at the time was he will consider it and then he will revert back to us.
Yes. Now, you move on from there at paragraph 436, where you explain what he said to you.
Yes. Advocate Abrahams advised that he was not prepared to authorize the issue of the poker authorization, the issue of the poker certificates at that time, and informed the prosecution team that he wanted additional information to be obtained and investigations pursuant thereto to be conducted.
Yes, and now that's the next annexure that I had to ask you to refer to.
That is correct.
Yes, which is at 1A899. Let's take us through those items that he was concerned should be given before he issued the before considering to issue the racketeering authorization.
Chairperson, the issues are dealt with in GSM 88 on page.
So what is GSM 88?
GSM 88 is a memo that the prosecution that I prepared as the lead of the prosecution team towards Advocate SK Abrahams. to deal with the issues that were raised in the presentation on 27 August 2015.
Yes. Okay, and what is the heading there in the term lines?
In the term lines, notes and comments after the briefing session to the National Director of Public Prosecutions on 27 August 2015.
Yes.
Pursuant to the briefing to the National Director of Public Prosecutions regarding the authorizations of the racketeering certificate, Mr. Mlocho, a team member, was tasked to compile a list of outstanding documents, investigations to enable the National Director to advance the matter with the National Commissioner.
Who is the National Commissioner referred to here?
In 2015.
No, but it's National Commissioner of what?
National Commissioner of Police.
Okay, so whoever was the National Commissioner of Police in August 2015.
2015. Who was the National Commissioner in 2015?
No, I'm not asking you to remember who it
Oh.
was. We can find that information out.
Yes.
I'm saying that what he's talking about is that he will be engaging with the National Commissioner of Police.
That is correct.
Yes. For what purpose?
With the in relation to the parts of the documents that he was not happy with, the organizational structure of the KZN, the entire police management structure, the organized crime facet thereof, as well as specifically the Durban organized crime.
Yes. All right, carry on. Minutes. Well, here it says here with other outstanding documents. What were those outstanding documents?
Those outstanding documents were minutes of the meeting at the provincial commissioners level regarding the operational successes and shooting incidents involving Ketomena serious violent crime.
Yes. Now, just on that issue of shooting incidents involving the Ketomena SVC, I mean, in this particular case, we're dealing only with a portion. But what was the actual scope or scale of the shooting incidents?
Chairperson, I do not follow the question.
In this case, your indictment deals with a limited number of shooting incidents involving Ketomena SVC.
Yes.
But what was the actual scale of these shooting incidents? Was it broader?
The scale was far too broader,
Yes.
as I indicated earlier. So what we did was we focused on those incidents where we are of the view that we would be able to bring evidence before the court that shows who participated in those incidents.
Yes. But this here is broader when it says shooting incidents involving the Ketomena SVC.
It is broad,
Means
yes.
they've shot a lot more people than they have been charged for.
No, they've shot a lot more people than we saw a lot more dockets than we decided to charge them on.
Yes. Thank you. Item 2.
Item Roman 2, the structures of the organized crime units nationally and provincially, as well as the names of the responsible incumbents in KwaZulu-Natal.
And what was the importance of this information?
The importance thereof was to see where to zoom at with the enterprise.
Okay.
To see whether, because the debate that we had was, is this the provincial organized crime as it is the entire structure, or is it the Durban organized crime portion of the entire KZN organized crime? And as I say, after debating and after looking at most of the information and look at how the events unfolded on the scene, we decided to zoom on Ketomena serious violent crime as the enterprise.
Yes. But this information was necessary to enable you to unearth precisely what the responsible unit is.
That is correct. That is correct.
All right. Item 3.
Item 3, the police standing orders regarding outside operations when a police unit or police officer is operating outside his or her area of jurisdiction.
Why was this important for Cato Man?
It was important because when there were lots of incidents in KZN, but there were some of the incidents that were outside KZN. So what we wanted to see was where internal processes followed when operations were going to be undertaken outside KZN. For instance, the operation that they conducted in Rustenburg.
Yes.
There was also another operation where, they would pursue the people that they wanted wherever they are, but we just wanted to make sure that when they operate outside the province, have they followed the standing orders? Have they followed the internal processes?
Yes, I mean places like Tembisa, Heidelberg,
Heidelberg, yes.
Yes, those ring a bell.
Yes, they do ring a bell.
I mean, what would be a reason for a Cato Minor unit to drive from Durban to kill a person in Heidelberg?
Yes, but that was what they were doing. Heidelberg is still nearer. Rustenburg in the northwest, where one of the incidents took place. I mean, it's really very far.
Or to kill a person in Tembisa.
To kill a person in Tembisa, yes, it's outside their jurisdiction.
Or to kill a person in Midrand.
That is correct. We saw those incidents.
But when you say where the correct procedures followed, I mean, what did you discover? It's unclear because the point that you ultimately arrived at is this is a killing machine. This entire thing is a killing squad.
Yes.
That's why it goes anywhere to kill a person and then go back.
That is correct. Irrespective of what the internal processes are, because they know they have protection from the level of General Johan Boysen.
Yes. Item 4.
Item 4 was
just a minute. I thought the question was as to whether there's anything that was found out about this issue of whether proper processes, internal processes were undertaken or not.
Correct. Thank
you. Can you please respond to that question?
Chairperson, the processes were not followed. They just did as they pleased because they knew they had the protection of General Boysen.
Thank you.
Thank you, Chair.
you. Item Roman figure 4 is standing orders on police operational plans. Why was this important?
It is important to see whether because ordinarily the information at our disposal was that an application has to be made for the operation to be approved first, and then only after it has been approved, then will the operation be executed.
So to just explain that, I mean, what we've seen here, just take the Magojela instance.
Yes.
On the 15th of September 2008, a telephone call is made to Mr. Mostert by General Boysen, where he says that I've got some information about the movements of the suspect.
That is correct.
Nothing happens on that day. The following day, at 6:30, the same call is made. Now there's specific information that the suspect is moving from Free State to Pietermaritzburg.
That is correct.
Give money to someone. Where do you say that that application ought to be authorized? That operation ought to be authorized.
What happens is if there is a particular operation that they were going to do that is planned, then an application is made to province for the application to be approved. But in an instance where it's emergency, like somebody that have been tracking that they haven't been able to get, and they receive information that he's in the vicinity, an approval would also be made telephonic.
Okay.
Yes. In case of an emergency, that approval would then be made by General Boysen or Commissioner Brown. Yes. Now, even if it were to be made telephonic, subsequent to the operation, because there would be financial implications. Subsequent to that operation, documents must be exchanged with province to show that that operation was a police operation that was approved.
So in other words, in each of the 23 dockets, there should be information inside the police showing that the operation was prior approved, and if there was no way of prior approving it, was approved telephonically.
That is
but
correct.
there is a paper trail for each of these operations.
That is correct, Chairperson, yes.
And there was no such paper trail.
There was no such paper trail.
I see. And does that confirm or disprove the prosecution thesis that this was a killing squad?
It confirms the theory that we're working on, that this was just a killing squad.
And then standing item Roman figure 5, standing orders on incidents involving police shooting.
That is standing order 251, where the police discharged a firearm in the course of their operation.
Yes, Leonard Jr. reminds me that we had come across that standing order as part of your affidavit to the Judge Zondo Commission.
That is correct, yes.
Which regulates how to implement Section 49 of the Criminal Procedure Act.
That is correct, Chairperson.
Madam Chair, I wonder if we can't, it's actually an important annexure, but I think we made an error by not including it. Because it's central to this case. It is available, but it's not part of the record. But that standing order 251 is a crucial piece of the puzzle. Do you have it, Advocate Maema?
No, I do not have it immediately.
Make a note, Advocate Ngcukaitobi, to have your junior get it.
Yes.
Then you can hand it up later.
Thank you, Madam Chair.
But you can speak to it if you remember its contents.
Yes. Can you outline? I mean, you are the one who's introduced Standing Order 251, so that's because you know it.
Chairperson, I had read it some more than 8 to 10 years ago, but it regulates the extent to which force or violence can be used. It is more or less Section 49(2), in which instances may police use force to overcome resistance when a suspect is being arrested.
Yes. What are those instances?
Well, the force that is regulated in the standing orders is in compliance with the force that is in Section 49(2). It must be reasonable force to thwart or to bring the suspect under control.
Yes. See, there is, perhaps let me do this to advance this debate. If you go to file 3, this file, the first page there is a judgment of the Constitutional Court in a case called S versus Walters. Can you see that?
I can see that, Chair.
The judgment by Judge Grichler.
Yes.
Do you recall this judgment?
Yes, I have read this judgment before.
What is it? It's a judgment that was dealing with what?
Chairperson, I've read it some times ago.
paragraph 1 of that judgment is telling.
Yes.
The case concerns the constitutionality of statutory provisions that permit force to be used when carrying out an arrest.
Yes. So it's the constitutionality of Section 49, subsection 2,
That is correct, yes.
allowing the police to use force.
To use reasonable force to bring a suspect to under control, yes.
Yes. Now, this entire discussion was settled in that judgment, and then the police then subsequently drafted standing orders to give effect to this judgment.
That is correct, Chair, yes.
Now, there is a summary of the circumstances in which force may be permissible at page 50, paragraph 54 of the judgment.
And paragraph,
54 of the
54?
judgment, page 50 of the bundle.
that is correct, Chair.
Yes. What does Judge Krichler say there?
Paragraph 54, in order to make perfectly clear what the law regarding this topic is,
And what is the topic?
the topic relating to the use of minimum force in effecting an arrest.
Yes. So the purpose of the force is to effect an arrest.
That is correct.
Yes. It's not to kill a
It's
person.
not to kill a person.
Okay. What does he say?
I tabulate the main points. A, the purpose of the arrest is to bring before court for trial persons suspected of having committed offenses. B, arrest is not the only means of achieving this purpose, nor always the best. C, arrest.
What are the other means of bringing a suspect to court?
You can issue a summons. You can warn an accused person to come to court. Perfectly acceptable method of getting a suspected person be.
Yes. I mean, if you look at, I think 10 of the people that they killed in relation to Nkosi Zondi and in relation to Superintendent Kongo, where there are 3 letters from the attorneys saying we will hand ourselves in. Would that be an acceptable way of effecting an arrest
That
or
is-
of getting a person to appear in court?
That is correct, Chairperson. That would be, a very effective way of bringing a person to book, bringing him to court. But Chairperson, also in respect of the Makojela, they handed themselves. They were handed to Ketomena by I think it was the Mtunzini police station. They were handed in,
Yeah,
and
those-
Ketomena said, "No, we don't want them. We will."
They're sent in by their own attorneys.
Yes.
All right, that's B. And then C.
See, arrest may never be used to punish a suspect. D,
In other words, where summons is appropriate, that's what should happen.
yes,
Especially when someone says, I'm here, I'm handing myself in.
yes. Instead of then you arresting a person on a Friday, and when you know that the courts are not operational on Saturday and Sunday, and only on Monday you can consider whether bail should be considered.
And then D.
D, where
Yes.
arrest is called for, force may only be used.
No, may be used.
Where arrest is called for, force may be used only where it is necessary in order to carry out the arrest.
It's just explain that concept because it's actually at the center of this case.
Where in instances where it is important to use arrest, force may be used only when it is absolutely necessary in order to bring an accused person to court.
Yes.
So it should be, you can't start with an arrest. It must be one of the last considerations.
Now, I'm talking about the use of force, but the purpose for the use of force is what?
Well, the purpose for the use of force would be to restrain, to bring that person that you are arresting under control.
Well, it says necessary in order to do what?
Necessary in order to carry out the arrest.
Yes. Now we have a man who is handcuffed and then is executed while handcuffed.
You have already arrested him. You have already restrained him. Is it necessary to shoot and kill him? It's not necessary at all.
And E,
Where force is necessary, only the least degree of force reasonably necessary to carry out the arrest may be used.
yes, that's also a crucial point here.
So even then, you use as minimum degree of force as reasonably justifiable in the circumstances.
Yes. So somebody fetches a malfunctional gun, which is not even in the body of the accused, and then they shoot them with a R5.
No, it is just it is.
Yes, and then F.
In deciding what degree of force is both reasonable and necessary, all the circumstances must be taken into account, including the threat of violence the suspect poses to the arrester or others, and the nature and circumstances of the offense the suspect is suspected of having committed. The force being proportional in all these circumstances.
Yes. And the constant theme here is that we were all under threat. I mean, when you look at F, would that be constitutional?
It would be unconstitutional. There was, in their instances, there was no threat. There was no reason to use violence.
Well, we have a 16-year-old boy who's sleeping, and then is executed with a machine gun.
That is just terrible, just bad.
And then G,
shooting a suspect solely in order to carry out an arrest is permitted in very limited circumstances only.
then what are those? In H,
In H, ordinary, such shooting is not permitted unless the suspect poses a threat of violence to the arrester or others, or is suspected on reasonable grounds of having committed a crime involving the infliction or threatened infliction of serious bodily harm, and there are no other reasonable means of carrying out the arrest, whether at the time or later.
yes, well, here we have no warrant of arrest. A man gets out of his house, he's naked, he lifts his hands, he's executed.
It is completely unlawful, unconstitutional.
And then
These limitations in no way detract from the rights of an arrester attempting to carry out an arrest to kill a suspect in self-defense or in defense of any other person.
Yes. But what should the arrester have been doing in those circumstances? I mean, what is the arrester doing when they kill a person? What is he trying to do according to this?
No, when an arrester kills,
No, but he's trying to carry out an arrest.
He's trying to carry out an arrest to
Yes.
kill a suspect in self-defense or in defense of maybe somebody that is.
I mean, on the 23 instances, was there a single one where there was an attempt to carry out an arrest?
No, there wasn't any attempt to carry out an arrest.
Yes. So would this be this is the law of the Constitutional Court. I mean, it doesn't, the Constitutional Court is clear on this about how the police must behave when they
That
are
is
in
correct.
possession of machine guns against
That is correct.
unarmed and defenseless suspects.
Who are posing no threat at all to them, to their lives, or to the lives of their colleagues.
I think it's been found that Standing Order 251, Madam Chair, it will be circulated later, but I need to proceed with the evidence in chief.
Yes, thank you.
Thank you. Now, we have to go through this on item 18900, item Roman figure 5, because it then takes us to what the Constitution actually requires, what the law in this country is.
That is correct, Chairperson.
Now, there's one more point that was raised by Advocate Noko, and I want your comment on it. Advocate Noko says, look, if you use disproportionate force, you become an aggressor yourself.
Of course, yes.
And therefore, you become guilty of murder.
That is correct, Chairperson, yes.
Is that the correct law?
That is the correct law, yes.
And she says, even in circumstances of self-defense, it no longer is self-defense when you are using disproportionate force.
Of course, then you become the aggressor.
Yes. Okay. Then item Roman figure 6.
Roman figure 6 is a minute of KwaZulu-Natal Provincial Command of the SAPS, wherein the killings of the suspects who allegedly killed Superintendent Kongo was discussed.
And what happened here? I mean, this is the funny thing, because this docket of Superintendent Kongo has been requested for 3 months from the NPA. It has not been produced. It looks like it was, this information was requested even in 2015.
That is correct, Chair. Even in 2012, when we started, we looked for this docket.
Yes.
But we felt we will be what do you call it? When you hamstring yourself if you say, I want to look at it first. If we can't get it, then we do other things and we see whether we will get it in the meantime. But we never got to get it.
And then they gave us a half-cooked docket in the killing of Inkosi Zondi, where it's so clear that they've removed various pages.
That docket, we were not able to get it.
Yes, well, it's been submitted here in these proceedings. But it's so clear that it's been tampered with. Now, then, so you made no progress there either on item 6.
On item 6, we made no progress.
If you can just remind me, the docket pertaining to the deceased Nkosi Zondi, I beg your pardon, the one that you say had been tampered with.
Yes.
Where do we find it? So that we can just flag it?
It was, I think it came from the researchers about 2 days ago.
Yes.
But we can find it now, the actual references to.
Yes. I remember they flagged them. Let me just ask our researchers. I know that they flagged those. Please come, Advocate Manganye.
I think I've got it. Yes. Yes, I think I've got it. It's BH0001, Becky Temba, CAS 113/01/09. You can just see, the first statement is A1, but it ends at A1 and then it doesn't follow, so the rest of it has been removed. Then the next one is unsigned. And there is also an unsigned affidavit of General Boysen, who says he was at the scene, despite everyone having telling us that he was never at the scene. But to answer your question, Madam Chair, it is BH 0001. Yes. Adv Tembeka Cas 113/01/09.
Our researchers will get that.
Yes. Well, they were able to give it to us. So we are grateful to them.
Yes, well, they brought them to our attention yesterday afternoon, so we didn't just get to go through them. Yes, thank you.
I'll show it to you. Sorry, thank you, Advocate Maema. We were at item 6. That's when we digressed to Nkosi Zone. That even the dockets the NPA has, you can see that there's been some work done on them. Now, Roman figure 7.
Roman figure 7 is the informer files relating to Ketomena SVC section and Major General Boise.
What is this referring to?
Informer files is police work on the basis of informers giving them information. And when an informer is giving information to the police, then they would they write a motivation for consideration or for approval of payment to the informer for the information that has been supplied, particularly when that information was successful in dealing with crime.
No, I'm talking about this one particularly relating to Ketomano, SVC, and Major General Poison. What is the point being made that the Major General Poison has informer files? Or what exactly is being made?
The point that is being made is that Major General, remember in the Magojela matter, as he was relaying information to the tracking team, he was relaying it on the basis of the informer who was giving him information.
Well, at least that's what he alleged. We don't know for a fact.
Yes. So what we wanted to see is if there would be an informer there, then ordinarily internal process would say, informer is giving me information, I had gone there, and the operation continued. So then what you would do is, if we procure the informer files will tell us, even if it doesn't identify the informer, it will tell us what information he had that led to the breakthrough.
Yes. Now what I'm saying is it the rule that if you have an informer in the police, there has to be a file relating to that informer? Even if the informer may not be identified, they could be identified by number.
By number, that is correct, yes.
But there is a file that exists.
There is a file that exists that relates to that informer.
And why is that so? Why should it be recorded that there is a file that we've got informer 2023, for instance?
Well, because then there is financial implications. That informer gives information and is paid on the basis of the information that is supplied. Now,
they had alleged, I know Major General Poison alleged that there was an informer. Even in the Nkosi Zondi killing, it was also alleged that there was an informer.
That is correct.
Yes. But when you look at that docket, there is absolutely no reference to any informer file.
Yes, well, in the docket, because the identity of the informer would be protected, you don't expect to get information related to the identity of the informer.
But what you don't see is even the
information.
Yes, the information that there is an informer, which is the source. Now, did you succeed in getting this information?
We didn't succeed in getting the information.
Yes. So you could never prove the claims that were made that Major General Poison was relying on informers.
We could not get the informer files.
Yes. And in that file, there is also payments made.
There is payments made. That is correct.
The Nkosi Zondi file, the very last page of that file, is 30,000 rands being claimed by Major General Poison, allegedly to be paid to an informer.
That is correct, Chair.
Yes, it is at page BH 0152. It says claim received from Director Boysen and forwarded for FA. The informer was paid the amount of 35,000 rands cash and received and signed by the informer. So all you say is that money was claimed by Director Boysen, paid to the informer, but you've got no other information.
That is correct.
May I come in here just to get clarity on the issue of the informers? We hear from your testimony that there is an informer file, or there's a file that is referred to as informer files.
That is correct, Chairperson.
Now, the informer file, is it each individual informer having a file, or is it a file that contains information of a group of informers?
Chairperson, my understanding from my interaction with the police is there is an informer file relating to a specific informer that would then have the claims that the police have made in relation to the information that informer had supplied, that would then lead to the solving of crime.
Okay, maybe let's talk about a case docket. Would a case docket ordinarily have information that suggests that particular information was obtained or received from an informer? Or is it something that is done separately from that very file that would have been created for the informer? And if you do not know, you should indicate. If you know, indicate, because it's important information. And yeah, okay.
Chairperson, my information is very scanty. It relies on my interactions with the police. So perhaps, not being a police, I should not even venture into the information relating to informers.
Okay, that's fine, and that's fair enough. It's not your area.
Yes.
But then, are you able to assist with the issue of whether in the main dockets, I mean, you've worked on very many dockets,
yes,
as to whether it would be indicated in the main docket, as to whether information, that specific information that is in the docket, was obtained from an informant or not?
Chairperson, in some of the dockets, Part B of the docket will indicate if there is information from the informer, and that informer would be referred to in a number as we have said earlier. But you find certain dockets where there is even the information, even the number of the informer is just silent.
So, from this statement, what you are communicating to us is that there are those where there would be an informer information, and there are those that would not reflect such information.
That is correct, Chair.
And you do not know as to whether it is a requirement that it appears in the case docket or not.
No, there is no requirement that it appears in the case docket. In fact, what happens is the police will try as much as possible to protect the identity of an informer, even to the prosecutor. So even if information information from an informer would be a breakthrough, the police would never at any stage reveal the identity or say anything that goes to the direction of revealing the identity of the informer.
Thank you.
Advocate, do you have a follow-up on the set of questions that you asked up to where the informer was paid an amount of 35,000 rands? we now know that after every killing, there would be a motivation for monetary award. Or I seem Twain is shaking his head vigorously. Advocate Twain is shaking his head vigorously. My apologies. Well, it might not be after every killing, but there would be a motivation for monetary award.
Yes.
That's the first thing. The second thing, we know that the Stenga Taxi Association would collect money to reward the Katomena unit who had carried out the murders. Now we have the state paying the so-called informer, while I take it that Major General Boysen would be the handler in the Magojela case, because he said he was in touch with the informer all the way.
Yes.
So he would have been his handler. So the handler gets paid by the state, the informer gets paid by the state, and there is the third payment from the taxi association.
Yes.
What does that mean, or what does it imply, where for the murder of one person, we have 3 payments coming into the hands of the role players?
Thank you, Madam Chair. The money to the informer presumably also goes to the handler.
Chairperson, it's like I indicated, having been a prosecutor, the information relating to informers is that of the investigators, and they guard it with their.
No, I don't think this is about informers per se, but it's just about the collection of cash relating to the murder of these people. So there are 3 sources. There is money that has been motivated by the state,
Yes.
anything between 10,000 to 35,000.
Yes.
There's cash payment going through the hands of these handlers to the informers. In this case, we know it was 35,000.
Yes.
And then there is the cash payments that the taxi bosses are also collecting. And we know from the statements of Dlondlo and Matonzi that in the one instance, I witnessed the collection. In the other instance, I witnessed the passing over of the cash. That's really the point.
Well, Chairperson, it's a system that these payments are just not proper in my view.
Yes, but what do they mean for the purposes of the prosecution in a racketeering case?
Chairperson, remember, for the prosecution, we want information under oath that we will be able to utilize in court.
Yes, but what is the effect of it on the operations of the enterprise?
I don't understand.
Well, if you have all of these payments made for the, what are these payments for? Was it to enable the enterprise to operate? What exactly is going on?
Yes, it would be then to facilitate to have an environment fertile for the enterprise to function in.
Yes. So does it support your case or not support your case?
It does support our case, yes.
Now, I did want to take you to the specific. I mean, you said that information about informers ordinarily would not be in the docket. I mean, in the Peggy Temba one, which certainly, in my respectful view, has been tampered with extensively, there's extensive references there to the interactions of the police and the informers. I mean, just as an example, if you look at BH 0147,
Is that the Peggy Temba case 113?
Yes, exactly.
1 of 09?
Yes. So if you look at the investigation diary.
Yes.
Are you in that page? Are you at which page are you at? Are you at
Page C24?
No, look at C19 of the investigation diary, which is BH 0147.
Thank you.
So just look at the bottom of the page. This is the 3rd of February 2009.
That is correct, Chair.
Yes. At the bottom there, it says...
Post entry informer phoned after he was tasked to trace OS suspect, which I understand to be outstanding suspect.
Then number 2.
Number 2, informer asked the suspect to pay his license disc of his car.
Yes.
And arrangements were made to meet for payment, and that was a trap for informer to trap the suspect.
Yes. 3.
The informer was further tasked to place the suspect in a place where he can be identified easily.
Yes. Same thing. 4. So you can go through every page there, but it's extensive references to the informer. That's why in the end, Director Poison now makes a claim, and then no one knows. It's said that the informer has signed for the claim, but there's no proof that the informer has signed for the claim. The only proof is that the claim was made by Director Poison. So that's why I'm asking you about these informers. You know, that you say the information will not be in the docket, but in one docket it's there.
In some of the dockets, it would be. In some of the docket, it would not be. But in all the dockets, you will never find an instance where a name and an address of an informer is disclosed.
I understand, but,
yes.
But an informer file will be there even if they are
yes.
identified by number.
Yes.
Now that takes me back to where I started. So the absence of these informer files from these dockets, a lot of these dockets, what does that mean?
Well, it means anybody can just say there is an informer file when there is in fact no informer file, or there is no informer at all.
Yes. And if it once existed, why is it not in the dockets?
Chairperson, if you ask that question, they would say, well, it will not be in the docket because they would not want the identity of that informer to be known. But the system is such that it is easy, even when there is no informers, for anybody to say there is information from an informer.
Yes.
Because such information, you cannot gauge its correctness against the contents of the docket, whether it's Part B or Part C of the docket.
Yes. So in other words, this informer system is capable of an abuse.
That is correct, Chair. Yes.
Now, on the question around why in some dockets there is no information of informers and then in others there is, I mean, did you work out why that is so?
No, Chairperson, we didn't work out why that was so. As prosecutors, Chairperson, our focus is, do we find a docket? Is there information in the docket that links us to a suspect? Can we charge that suspect? You know, the rest of the things we didn't. We would question some of them, but our focus is: do we find case dockets where we can, where there is evidence implicating somebody in the shooting, and is there sufficient evidence to charge that person?
No, the problem is that it's your own reports that is talking about looking for these informer files.
Yes.
It's the prosecutors themselves that are looking for the informer files under item Roman figure 6.
Because, Chairperson, what we wanted to see, we wanted to see if this assertion that they are informers, that they are making, are they genuine assertions or whether they are incorrect. And the only way of doing so was to check if they were they in fact had informer files that had claimed for and that they have paid, without getting the identity of those informers.
And then you found that actually in the majority of cases there were no such files.
We found that there were no such files. Yes.
Thank you. So then there's Roman figure 7.
And sorry, Council, on page BH 0152,
Yes.
C24. You see against the date 09 March 2009, it says claim received from Mr. Boysons and forwarded for FA. What is FA?
Well, we understood it, Madam Chair, to be financial approval. Yes.
I also understand it the same way, Chairperson.
Thank you.
Thank you. Thank you. Where we are at Roman figure 7.
That is correct, Chair.
Procurement documents relating to the resourcing of the Ketomano SVC section.
That is
signed by-
Roman 8, Chairperson.
Oh, we are in 8. So where are we? We finished 7.
We finished 7.
So we are on 8.
On
Yes,
8.
correct.
Procurement documents relating to the resourcing of the Ketomena SVC section, signed by Major General
I think
Boyce.
you've now got the hang. I'm asking you, why was that important, and did you actually get it, and what did it tell you?
The procurement documents relating to resourcing.
Yes.
Yeah, here it would show that Major General Boysen had rendered Aya as head of the Devon organized crime redundant. So he was dealing directly with the procurement and resourcing of the Ketomena SVC, as if he is their commander, when the real commander was supposed to be Aya.
And then what did you find here?
We found that Major General Boysen made sure that they were fully resourced. They had fully functional cars with sirens. They had, they were the elite unit. They had everything. In terms of equipment and everything, he made sure that they were fully resourced.
No, but in relation, your point, as I understand, is not whether they were resourced or not, but your point is that the person who was responsible for signing procurement-related material, instead of being Colonel Aya, was Major General Boysen.
That is correct, yes.
What I'm asking you, what did you find when you were trying to establish that information?
Well, we found that it was Major General Boysen who was resourcing the Ketomena SVC.
No, but who was signing the documents? Because the resources are coming from the state.
Major General Boysen was the one who was signing the supply of whatever resource that Ketomena required. When it was supposed to be Aya who was signing it, it was Major General Boysen.
Yes, thank you very much.
That signifies his role as the boss or as the manager,
That is correct, Chairperson.
somebody who has control of this unit.
That is correct, yes.
Yes. And then,
But sorry,
Yes.
but did you find the actual documents with his signature? Did you at some stage receive such documents?
We did, Chairperson. We saw where he procured torches, where he procured what do you call this thing? Reflector jackets. He made sure that they were resourced, and it was him who signed, him who would approve all of those procurement memos.
And Council, there is something to that effect in these documents.
yes.
Your junior will probably take us there,
Yes.
where mention is made of the very point the witness is mentioning.
Yes.
And it may well be that there are those documents that you are referring to in relation to the point.
That is correct, Chairperson.
And moving of offices and then Major General Boyson overturning it.
That is correct, the moving of offices.
Let's explain that to the panel.
Chairperson, what happened is Colonel Aya issued an instruction that they must move from where they were to the Durban organized crime. Now, there was huge resistance, and they went to, they complained that, you know, where the Durban organized crime office will not be conducive for questioning suspects, but they resisted, and Major General Boyson said it will not happen, don't even worry about it. So they had the protection from General Boyson.
But he himself issued the letter. Major General Boyson wrote the letter, signed it himself.
Chairperson, referring to the letter moving them.
Yes, the letter telling Colonel Aya that they will not move.
Yes, General Boyson himself said they will not move. So they knew that they had the backing of General Boyson at all instances.
We will find those 3 documents. Then Roman figure 9, NDPP to facilitate the signing of Danicas Greek witness statement. We've gone through the iterations up until the final one was signed.
That is correct, Chair.
And you mentioned that what was your evidence on the signature appearing in the English version and in the Greek version of Mr. Danicas? Do you have any personal knowledge of that or not? Because you said at some point you were moved from the case.
No, what happened was when the statement, the English statement was produced, and prior to the Rule 35 discovery of the document to the defense, I then had to make sure that I send it to Danicas so that he can confirm the translation. Now, when he indicated that he showed me, I think, 3 or 4 mistakes in the letter, in the affidavit.
In the translated version.
In the translated version. I then brought it to attention of the extradition desk and said, I'm informed that there are these 3 mistakes in this translation. Can it be presented to the same? Can it be presented to the translator to confirm and or to correct? And then there was that discussion as to whether the same or a different one. I said it would be better than if it's the same. But if they can't get the same, present it to anyone that you find. But then what happened was when the translator translated from Greek to English, they then took the signature of Mr. Danicas from the Greek statement and superimposed it on the English statement. So they take a picture of the signature and you superimpose it on the English version. Now, the NPA at some stage was of the view that I am the one who did that superimposition.
Well, not only the NPA, even Advocate Batoy in this DeCock report made this astonishing accusation that it was you. Yes,
and then fortunately, there was a trail of letters between me and Laxen Ngiva of the extradition desk, relating to all of this. And yeah, I would never have superimposed a statement.
No, I mean the problem was that they read an email from you where you said it was superimposed, and then they just missed the it, and then they said you admitted that you had superimposed it. You are not in a trial today. Advocate Chauke is in a trial.
That is correct, Chairman.
Yes, thank you. But when Advocate Abrahams was concerned about the facilitation of the signing of the of the Danicas statement, what was that about? That really was the question.
Well, the question, because we are going to use Danicas as a witness. We wanted to obtain his statement, and the NDPP would facilitate. That means if I would ask for approval of the trip to go to Greek, then the NDPP would consider it.
Yes, but why was that considered important? Remember that at this point we already had the unsigned statement, which was criticized by the judge. And then at this stage, when Mr. Sean Abrahams comes in, why is it important? Because it's talking about the signing of a statement.
Well, it is important because a signed statement will add to the evidence that we have with regards to the Ketomena SVC. Because we wanted somebody inside who would tell us how they operated. Initially, we thought one of the accused persons would agree to become a 204, but then it never materialized. We asked the DPCI and IPED to see if any one of the accused persons were willing to turn a Section 204, but it was not fruitful.
I saw in this report of the court that they also talk about Mr. Danicas as a Section 204 witness. Was that correct?
No, he has never been a Section 204 witness. We never had any information linking him to participation in any offense.
Yes, thank you. So you thought, Advocate Abrams thought the signing would strengthen your evidentiary material?
That is correct, yes.
Which we know was in fact obtained.
Yes.
Now, item 10.
The following documents from Assistant Commissioner Brown's statement attached here too for ease of reference to be obtained. POCOC Instructions 5 of 2000 and Instruction 5 of 2001. That is a provincial organized crime it was an organized crime instructions that was issued by the Provincial Commissioner's Office. Files or any documents kept by Lieutenant General E.G. van Rensburg, who headed the Transport Violence Investigation Task Team, because we thought these documents would assist us in seeing whether there is, because when you have a resource which is a car that is going to be utilized, whether particularly outside the province, yes, there must be documents relating to the utilization, who uses that vehicle, for what purpose it is being used. So we thought there might be information relating to the use of their cars if they're going to engage in an operation outside the province. The next bullet, documents kept for Provincial Priority Committee for Transport Violence, chaired by Major General Poison. We also thought these documents could shed light on if there is an operation that they're going to undertake outside the province. We thought there could be some information in that document that would make it easier for us to get more information. The next bullet, provincial TVPC ACA files. We were talking about the ACA liver files. The next bullet, documents of the...
What's this TVPC, this acronym?
Chairperson, I have forgotten what the TVPC is. There are just such a lot of acronyms. Now, having been out of the environment for some time, I've forgotten now what they are.
Council?
The next bullet, document of the PCCF and...
And how were these official files pardon? How are they going to assist?
Chairperson, we thought in those documents we will find information, particularly the motivation for the use of when they seek approval. We thought it would indicate why are they going there. You know, it will give us, it will shed some light to, in order to guide the investigation.
Which point are you referring to? There's one that specifically is asking for the priority committee for transport violence chaired by Major General Boysen. And then there's the provincial TVPC, Atrafai.
Chairperson, particularly those where Major General Boysen was involved, we thought we will find information that would explain most of the activities that they were engaged in. And then the NDPP would then speak to the assistant commissioner or the commissioner to make it easier for us to obtain some of those documents. We would also remember that most of those documents would be classified and will have to be reclassified in order for them to be released to be used by us.
Yes. Yes. Next item.
And the next bullet would then be documents of the PTCC. I also cannot remember what the PTC is.
No, PCCF.
PTC.
PT.
PCCF.
Or you are at provincial P. Where are you now?
I was at the last.
No.
The last.
There's before that.
Before that,
Oh,
there's
before that?
also PCCF.
Documents of the PCCF and Prof joints relating to the taxi violence between KwaMaphumulo and Stenga Taxi Association. And
What is that? I mean, that seems to be directly relevant because
Yes.
it's addressing what we are dealing with in this case.
That is correct. That is why we were seeking documents relating to, or reports relating to taxi violence between KwaMaphumulo and Stenga Taxi Association.
Yes. But why would they be at province?
Chairperson, at the Prof joints, there is any issue which is a thorn in the province is discussed at the Prof joints. It is discussed
What
at
is
the
this
provincial level.
Prof joins?
It's a joint committee of the police, prosecutors,
I see.
justice, to deal with the issues that are challenging in the province.
Yes, I mean, the reason I'm asking you about this is that there is the oddity of this case of two allegedly warring taxi associations, if they were warring at all, but being assigned to one unit, which is also a very localized unit. And geographically, this also doesn't make sense. You know, why would you say Stenga and KwaMaphumulo must be assigned to this particular unit?
Chairperson, Ketomena in KZN was perceived to be a fire extinguisher. It was perceived to solve the challenges that they had in KZN.
I see.
So they would utilize them for most of the things,
Yes.
for most of the challenges, particularly the violent ones.
Yes.
That is why when you got there, we looked at various categories of offences, ATM bombings, taxi violence, as well as just ordinary criminal gangs. They were utilized all over. Even when there is a bus strikes or taxi, when there is a, what do you call it, a boycott of buses, they would use ketamine.
Yes, as you call it, a fire extinguisher.
Yes, they were the fire extinguisher.
Which did in fact extinguish the fire, but started it.
Instead of extinguishing it, they do other things. They kill.
All right. You were at documents of the PTCC, which you also said you didn't know what it was.
I cannot remember what the PTTC is.
That might not be helpful. And then any other relevant document pertaining to the activities of the Ketomani unit for the period 2008 to 2011. That seems to be a generic
That is correct, Chip.
request. Now that document is then signed by yourself.
Yes.
Yes. Now that was in
On the 27th August 2015.
yes. That's the memorandum you sent immediately after the meeting with the Advocate Abrahams.
That is correct, Chip.
And these are the documents, as I understand, that he needed in order to consider what to do about the fresh racketeering authorization.
That is correct. Whether our identification of the enterprise was correct, whether we had placed it correctly when we said part of Devon organized crime, or whether we needed to go provincial. Yes.
So you say you obtained some, but not everything.
We obtained some. We did not. We could not obtain all. Yes.
Yes. Is that what you are dealing with at 438, paragraph 438?
That is correct, Chairperson. Having obtained these items, I amended the prosecution memorandum. My October memorandum of 2015 was submitted to Advocate Abrams with an application for authorization from Advocate Noko during October 2015 with a drafted POCA certificate.
Yes. All right, carry on. And again, here, Mr. Chauke, who was charged for all of this, is not playing any role.
He is not playing
sitting
any
idly
role. Yes.
in Johannesburg.
That is correct, Chairperson. So it is unfair, really, to ascribe decisions that were made by the prosecution team to him. It is me and my prosecution team who made that decision. And if NPA has any quibbles with it, it's me that they have to face.
Yes.
But strangely, Chairperson, I waited since 2019 until I left in 2023 to be charged. I was removed. I was coming to the office reading the newspaper. I wasn't charged because I wanted to answer and tell them why all of these things happened.
And paragraph 439?
Advocate Abraham was still not satisfied with the prosecution memorandum and the POCA applications for authorization and instructed me to travel to Greece to consult with Mr. Ari Danicas. I already had in my possession Danicas' unsigned statement, which was Annexure NJ3 to the answering affidavit deposed to by Advocate Jiva in the matter before Govan J.
Paragraph 440?
Paragraph 440, I then met with Mr. Danicas on 19 January 2016. I consulted him on 20 January 2016. He was accompanied by his Greek lawyer, whose name I will not attempt to call out, and an English barrister, Olive Powell. I was accompanied by the head of the Witness Protection Program, Mr. Dawood Adams. Mr. Danicas supplemented his aforesaid statement, NJ3, and handed me additional photographs and video clips on a flash disk. I then requested Danicas to ensure that the contents of our consultation are part of the statement that he will furnish to me through diplomatic channels. Consequently, I then returned with Mr. Danicas' supplemented but unsigned statement.
Yes.
What I mean by then he ensured that the contents of our consultation are also included in the statement. There are issues that I asked him to deal with, incidents that he could remember. So I wanted him to deal with those incidents in the statement that he would make.
Yes. Well, you read it yesterday. I mean, it's extensive in relation to incidents.
Yes, it is.
Thank you. 441.
441, Mr. McAdams and I briefed Advocate Abrams regarding our consultation and then handed him a copy of Mr. Danicas' supplemented statement, and also showed him certain photographs and video clips on the flash drive concerning the manner in which Ketomena SVC dealt with suspects.
Yes.
Thank you. You may pause there, Advocate Maema, Advocate Ngcukaitobi.
Yes, Madam Chair.
I will take a tea break until 11:45.
Thank you, Madam Chair.
You are still under oath, Counsel.
That is correct,
Chair.
Chairperson.
Good afternoon. Oh, good day, everyone. Good day. Advocate Chauke. Good afternoon, Advocate Maema. You are still under oath.
Good afternoon, Chairperson.
Good afternoon. Are we in the afternoon now?
Almost.
Almost. We have an hour to make some progress. Advocate Ngcukaitobi,
Thank you, Madam Chair.
you may proceed.
Thank you, Madam Chair. An update. We found some of the correspondence we were dealing with yesterday, and my Leonard Jr. will liaise with the researchers. Yes, thank you. What we haven't been able to find is what we were talking about this morning, but it will also be traced.
Before you proceed, we have now been given the answering affidavit in relation to Advocate Batoi's application.
Oh, thank you.
As regards the replying affidavit, I don't know who's going to update us because Adv Tembeka is not here. Neither is Mr. Simele Mecha. Is there anybody from the state attorney? There are so many interlocutory applications that I'm getting confused now. My law researcher, Attorney Moerani, correctly reminds me that the answering affidavit is an answer to the decoupling application by the NPA. And we were told that the evidence leaders are, let me correct myself. The evidence leaders have not indicated what their position is as regards the decoupling application. What is the position?
Madam Chair, as we indicated, I think it was yesterday, I can't recall, but earlier this week, we indicated that we will not be participating in that application, we will be abiding. And I think, Madam Chair...
No, that is the substantive application by Advocate Batoi.
No, even in the decoupling application, our position is we will not be
Are
participating.
you now telling us that you will file a notice to abide as regards the decoupling application?
Indeed so, Madam Chair. We will, Mr. Sello Maema will attend to it. We will make sure that he delivers the relevant notice.
If I may sound a caution, have you read that application? Because certain allegations are made about what the evidence leaders did not do. I'll caution that you reconsider your position.
Whether to oppose or not, Madam Chair, we'll take heed of that, and if needs be, if there's a need for us to file an affidavit dealing with those allegations, we will do so.
Yeah, I'm just mentioning because we have read that,
Yes.
the application, and it is somewhat strange to me that you don't even seek to answer those allegations pertaining to yourself as evidence leaders.
We'll take Madam Chair's advice and reconsider.
You may wish to reflect, and you will let us know tomorrow morning what the position is.
Indeed so, Madam Chair.
Advocate Ngcukaitobi, we have now been given the your answering affidavit
Yes.
in the decoupling substantive application.
Yes.
We will look at it later.
Thank you, Madam Chair.
Thank you. And there seemed to be no indication about the filing of a reply in the notice of motion of that application. And I'm disappointed that nobody from the state attorney is here to be updated about what is to happen except the junior advocate. When do you propose to file a replying affidavit, if any?
Thank you, Madam Chair. I'm waiting for instructions, but there is an intention to file a replying affidavit. So we're just confirming with client. Thank you. Thank you, Madam Chair. I was saying that there is an intention to file a replying affidavit. In fact, my senior is settling a draft, and we're trying to confer with client. They have a strat plan, so we're not getting speedily responses. But to confer with them in relation to the deposing of the replying affidavit. So I'm unable to commit a time or a date when the replying will be filed, but I doubt it will be today.
Yes, thank you. In the notice of motion, you made no mention of when you will file your replying affidavit.
Madam Chair, if my memory serves me well, we did. The panel would recall that the timeframes had been moved forward to allow the teams to respond to the application because the times were truncated. So they were moved. But I think what I can accept is that in relation to the replying affidavit, there would have been no indication of when will that be filed.
Is there any indication in the notice of motion?
I should think so, Madam Chair. When I drafted it, I put in the date. Yeah.
Yes, thank you.
Thank you.
We are asking these questions because we have to decide on how we are going to deal with that application, whether we deal with it on papers or we afford you an opportunity to file written submissions, or you'll argue on your feet. Because we don't have time to be dealing with this so many interlocutory applications instead of focusing on the real crux of the matter, why we are here. Yes, thank you. The Advocate Ngcukaitobi.
Thank you, Madam Chair. Advocate Maema, we were just about to deal with the authorizations by Advocate Abrahams in February of 2016, correct?
That is correct, Chairperson.
Yes. Now, there's something in the DCOC panel report which says that, well, it was not correct for Advocate Abrahams to issue his authorization because even at that stage, the affidavit of Mr. Danicas had not yet been signed. But the previous paragraph you've just read, that you actually returned from Greece with a supplemented but yet unsigned statement. Is that correct?
That is correct, Chairperson.
Yes. Was there anything untoward in Advocate Abrahams issuing the POCA authorization, even though the affidavit, the statement at that stage was not yet signed?
No, there was nothing untoward. We on the discussions that we had with Mr. Danicas, we were convinced that the statement would have been signed. And remember, from the beginning, I didn't want to have a statement signed and commissioned by us in Greece, and we bring it here contrary to the provisions of the Mutual Legal Assistance Act, because it is clear in the provisions of the Section 2 and 3 of the Mutual Legal Assistance Act that as a witness who's outside the country, if you intend to use this statement in a subsequent trial, that statement has to be channeled through diplomatic channels.
Yes, no, I understand. Now, I'm just asking now a narrower question about the absence of signature or a so-called deposition, because the report says it was unsworn.
There is nothing untoward because the POCA does not require information to be under oath.
Thank you very much. So it's on that basis then that you've now done the supplementary information gathering. You've
is
gone to
correct.
Grace, you've spoken to the witness. You are confident the witness will testify.
That is correct.
But you have a reason not to disclose that the witness will testify.
Yes.
And what is that reason?
That reason is, the more we say he's going to testify, we are the ones who are placing his life in danger. And if we say he's not going to testify, then the focus shifts on him, and he becomes a little bit more settled. So if we to say he's going to be used as a witness outright in the public, the effect it puts a lot of pressure, and it attracts a lot of untowards towards him.
Yeah.
Toby,
Yes.
give us just a minute.
All right.
Thank you, Counsel. I'm sorry to interpose. Just settling an urgent matter. You may proceed.
Thank you. Now, the witnesses you were disclosing at the time, okay, excluded Mr. Danicas, but were there any other witnesses that were in the same category that you felt for security reasons should not be disclosed? Remember that we had looked at the statements 2 days ago, I think, of Ndlondlo, whose details were scratched out, and I think Matonzi, whose details were also scratched out.
But in the category of Mr. Danicas' witnesses who were outside the country, he was the only one.
No, I'm talking even local witnesses that you felt you didn't want their identity to be known for the same security reasons.
Yes, there were other witnesses whose identity we didn't want revealed for the same security reasons.
Can you remember them?
It would be Matonzi, it would be Ndlondlo, Beki. What is Ndlondlo's name? Yes.
Yes. Now, why specifically was it an issue that there was a security concern?
Chairperson, any person that had anything to do with Ketomena would tell you that when they are involved in any matter where they are involved, anything can happen to them. So they are their lives would be at stake. A witness, even Chairperson, remember we spoke about Bar. Even when he came to consult us, he was very scared. They were very scared of their lives.
Yes. Why were they scared of their lives?
Because of Ketomena was the law unto themselves. We remember in one of the conversations it was said, I can make somebody disappear. So Ketomena was very feared. They referred to them as Kito, and they were very scared of them.
Yes. All right. So, Mr. Abrams has now, Advocate Abrams has now signed the authorization on the 13th of February.
That is correct, Chair.
2016, paragraph 443.
Paragraph 443, the second authorizations with the accompanying prosecution memorandum were based on the contents of the docket and the following statement to show that there was a police management structure under whose command responsibility the murder and offences were committed. 43.1, the KZN provincial structure. Subparagraph 2, statements from Durban Organised Crime Unit Commander Aya. Sub 3, statements from KZN Provincial Head Office Assistant Commissioner Brown. Sub 4, agent application papers under case 13759 of 2008 instituted by Mr. Bongani Mkhize, wherein he successfully interdicted the Ketomena unit from unlawfully killing him. Sub 5, draft statements of Mr. Danicas after consultation in Greece. Point 6, motivation for monetary and non-monetary awards which demonstrate that Mr. General Boysen and members of his command, excluding Colonel Aya, received money and non-monetary awards for the killing of people who were suspected of the killing of Superintendent Kono. Point 7, statement of Matonzi which explained how the plan to eliminate members of KwaMaphumulo Taxi Association were hatched and orchestrated. Point 8, statement of Ndlondo brackets Mtiani, which explained the role of Stenger Taxi Association in the killing of members of KwaMaphumulo Taxi Association by members of Ketomena unit. And point 9, statement of Mkhize, which singles out the incident of the killing of Kopolo Danduli and Natim Tembu, who were members of KwaMaphumulo Taxi Association.
Thank you. You've already dealt with extensively with why you believed that evidence to have been sufficient, and you've explained the draft statement of Mr. Danicas.
That is correct, Chair.
Section D we dealt with that yesterday because we had to address the DCOG panel report.
Yes.
Can we skip to section E, which is at paragraph 484?
That is correct, Chair.
Now, this is now the Batoy era. It was once the present era, but it's now the past era as well.
That is correct, yes.
Can you deal with that? I mean, I know right at the beginning, on day one, you wanted to get into this phase, and we kept asking you to hold on.
Chairperson, yes.
I beg your pardon, Council. I thought that we went through this report, or are there specifics?
Yes,
Thank
there
you.
are specific parts, not this section of the Batoy era. Yes. Now, there is 485. Can you deal with that?
On 12 April, I was instructed by Mr. McAdam, the acting special director at the Priority Crimes Litigation Unit, to hand over to him all Ketomena dockets. During this time, there was a pending High Court application where the accused had sought to challenge the aforesaid racketeering authorizations. This process had halted the commencement of the trial.
Now, I want to also address 486 because yesterday, I'm not sure if you had forgotten or what had happened. When you dealt with that meeting of the 8th of July, when everyone was convened by Advocate Batoy,
Yes.
to inform them, and I asked were there any responses, and then you said, well, the hierarchy in the NPA is that when a decision is made, there are no responses. Now, the problem is that that is at slight variance with what is contained at 486, 487, and 488, 489, and 490, because it seems that what actually happened is there was a pushback in that meeting. Can you look at your statement?
On 8 July 2019, the National Director of Prosecutions Advocate Batoyi convened a meeting where she invited the prosecution team and advised us that she had constituted a panel to look into the Ketomena prosecutions. A report had been received from the panel, which was led by Advocate Dikok, and the recommendation with which she is in agreement was that all the racketeering authorizations should be withdrawn.
Yes.
487, the prosecution team and I in particular raised a concern as to how the panel could make such a recommendation without consulting the prosecutors who had long been seized with the matter.
Yes, if you can just stop there. Now, I think yesterday you said once she made that the meeting was over in 2 minutes. Now, that's what I need you to clarify in the light of the paragraphs that come after that.
Chairperson, yes, I in particular, and I remember the team members also saying, but how is this possible? How can we were really taken aback? How can a decision like this be made without our views being heard? Yeah, and all that she told us was she has taken a decision, and that's where the matter ends. That is why I say.
Now I'm saying, just in fairness to yourself, I'm specifically driving you to respond to yesterday, having said she announced a decision, the meeting was over in 2 minutes, but in your statement saying actually we responded to her position. So it could be that your recollection yesterday was not correct, and you can just explain that to the panel that you made an error, but this is what actually happened.
Chairperson, whatever concern that we raised was completely brushed off. So I myself overlooked the resistance that we tried to show there. So yes, I had made a mistake when I said it was. But the meeting was very brief and short.
Yes.
It was made clear to us that whatever that we would say would not change her mind. Decision has been made. She is withdrawing the racketeering authorizations.
Yes. Thank you very much.
Sorry, a follow-up. Mr. Maema, your previous statement that the meeting lasted just 2 minutes and no one said anything, was it meant to mislead this panel into looking at the former NDPP as someone who never engaged?
Chairperson, with the greatest respect, I would never mislead. This experience has been very painful to me. This experience was not pleasant, and even that day, I look at I would want to forget what happened on the day. I would want to forget that I was ever a member of the National Prosecuting Authority, because of how the era of Advocate Batoyi treated me. So it could be in that vein that I then made a mistake and said, it was just one way, we being told what happened and the meeting being over in a second. Chairperson, I apologize if I would give an impression that I would want somebody portrayed in a light that that person is not actually what he or she is.
Yes. Thank you. That's what I needed you to just clarify. That's why I took you back to the statements, just to reconcile them with your statement yesterday.
I appreciate that, Chairperson, and
yes.
I applaud you for it.
Well, it's nothing I've done. I'm just helping you as a witness. So just not to get yourself in trouble.
It helps my healing, Chairperson.
Advocate Maema, there has been developments pertaining to you in particular recently, as of November and December 2025, when evidence was given here. And do you want to explain to the panel what actually happened about criminal charges involving yourself?
Chairperson, on a particular date in, I think it was this year, early in January, I received a call from a police officer whose name I noted in my book. I was jogging in the morning, and I said, "Well, I'm on the road. I will give you a call when I get home," because the call I received very early in the morning, around between 7 and 7:30. When I got home, then I called the person. I returned the call, and he identified himself as an official from the unit that is headed by Advocate Johnson in the NPA. So it was an investigator and a prosecutor who wanted to let me think. What did they say they wanted to do? They wanted to serve a J175. A J175 is a subpoena to appear in court. And then I wondered, J175, what are the charges? And I was told the charges are 3 counts of fraud. And I asked, what are the basis of the fraud? And how am I summoned to court without my version having been heard? Because when there are allegations of commission of offense against anybody, the prosecution policy, as well as the Audi alteram patem rule, requires that you hear the other side, you hear a version from the person that you have allegations against. The officer then went out and made a call and spoke to Advocate Paul Lowe in the office of the National Director, and then came back and said to me, "No, we will give you what the contents of the allegations in writing, and we give you until a date in February this year on which I should then submit a warning statement of what my views are," because it was difficult at this stage to say what my views are when I don't have particulars of the said fraud allegations. So that is where and then what I did was, when the allegations were not forthcoming, I then sent an email to that official of the NPA to ask them if they are going to want a warning statement from me. Maybe the best thing would be to place me in possession of the dockets that we had at the time that we drafted the indictment. Then I'll be able to give them a full account of my involvement in the Ketomena matter.
Mr. Maema, I got my information in this inquiry in the second week of December from Advocate Chauke that you had been approached by these members of the NPA shortly after we had announced you as a witness. So who between the two of you, whose recollection is correct?
No, it was then. I made a note of exactly when it happened, the day that it happened.
Well,
In my
can you
book.
just check your note? Well, the last time you checked your note, it didn't turn out well, but anyway.
Chairperson, I did make a note.
Are you asking for the date on which he received the J175?
The date on which he was approached by these investigators, that's what I understood.
Or subsequent to receipt of the J175?
Yes.
Okay, thank you.
I have found the note, Chairperson,
When was it?
on the 12th of December 2025.
Yes.
Yes, I say on Friday, the 12th of December 2025, at 6:31 in the morning, I missed a call from this number, and I say what the number is. The number called me again at 0759 as I was training, as I was doing road running. I had my phone in my pocket at the time. I recently started training, so I thought if I have trouble, I can phone my daughter to come and collect me.
So Advocate Chauke was correct.
Advocate Chauke was correct.
Yes.
I
Now-
answered the call and promised the caller to call when I finished. He indicated he will call later.
Yes. You've already told us that. Let
Yes,
counsel
yes.
proceed.
Now, these alleged fraud allegations, what do they relate to?
They related to my involvement in the Ketomena team.
In the Ketomano case?
Yes.
Yes. Now, the 12th of December was day 2 of the cross-examination of Advocate Batoyi. Yes. And your name had been announced as a witness.
That is correct, Chair.
Yes. Now, how did you interpret people alleging you've committed fraud because you've brought a case against against Major General Boyson in the middle of the cross-examination where you are a witness?
It was very strange. I was wondering whether it's a scare tactic to scare me from involvement in this proceedings. That is the only way I interpreted it, because all of these things happened long time ago. Why only at that stage? Only after the announcement that I would be asked to come and testify.
Yes. That was the fear of Advocate Chauke, that you were being intimidated.
Well, I also had the same fear, Chairperson.
Thank you, Madam Chair.
You said earlier on that you had been following the proceedings.
That
of
is
this
correct.
inquiry.
Chairperson. Yes, I have.
In other words, by the 12th of December 2025, you would have known that Advocate Batoyi was on the second day of her testimony or of her testifying under cross-examination.
That is correct, Chair. Chairperson, I have the name of the member of the DPCI who came. It's Captain McLeod. Captain McLean. I wrote it M, capital M, little small c, and L-E-N. M-C-L-E-A-N.
M-C-L-E-A-N.
L-E-A-N. McLean.
Yes. Yes, thank you.
Madam Chair, I have finished my evidence in chief. I have the standing order. I'm not sure if it has been circulated, but We have the standing order now. Perhaps the witness can look at it if he wants to comment on it.
Thank you.
Your memory in some parts is very sharp, Advocate Maema, because you immediately announced it as Standing Order 251. So it is Standing Order 251.
It is, Chairperson.
Yes. Is there anything you want to add on the Standing Order? It was around the issue of Section 49(2) of the Criminal Procedure Act and the parameters of the use of force in the context of effecting an arrest.
Chairperson, you can see also at paragraph 251.5.4, it refers to section 49(2) of the Criminal Procedure Act. So it mentions the parameters within which force can be used by the police, and this is one of the documents that we looked at because it was clear in the dockets that we were analyzing that there was use of force. We had to look at what internal regulations say insofar as the use of reasonable force in dealing with a possible resistance or a possible thwarting of a refusal to be arrested.
Well, I mean, under 251.5, it sets out the circumstances in which members may be justified to use force. Those are tabulated under 1, 2, 3, 4. What are those?
Chairperson, specifically members justified in using firearms under the following circumstances. If their station or barracks is attacked, if an attempt is made to relieve them of their prisoner or deprive them of their arms, to defend themselves or any other person or persons from death or serious injury if attacked, for when other means are ineffectual to effect the arrest or to prevent the escape of a prisoner convicted of a serious crime or of a person who has committed or is suspected of having committed an offense included in Schedule 1 of Act 51 of 1977. In this connection, attention is especially drawn to the provisions of Section 49, brackets 2 of Act 51 of 1977.
Then I'm also interested in the next one. It's also very crucial, 251.6.1.
Chairperson, it says it must constantly be borne in mind that however justified a member may consider himself to be in shooting, whether or not the results are accompanied by loss of life, this act, with all its accompanying circumstances, will have to be subjected to an investigation. A member who is placed in such circumstances shall have to prove that he acted with all reasonable care and without recklessness or negligence, but that he was compelled by the circumstances to make use of his firearm, and that the degree of force and nature of the weapon used were not out of proportion to the circumstances necessitating the use of force.
Yes, if you can just stop there. I mean, it's most extraordinary. The own standing order places the onus on the shooting policeman.
Yes.
To show that the shooting was justified.
In the circumstances, yes.
And then it places an onus on the police to conduct an investigation. And where that investigation is conducted, it's up to the shooter to show that the shooting was justified.
Yes.
And here we found two glaring instances where firstly the investigations are superficial and they are never put to an onus to justify the shooting, the policeman.
Yes, it is contrary to what the standing order provides for.
Thank you, Madam Chair. I have finished my evidence in chief. Thank you for the time.
May I ask some questions, especially with regard to that paragraph 251.8.1? Do you see that?
251.6.1.
0.6.1, thank you very much. Yes, you are correct. I'm trying to understand exactly how the IPID or the DPCI works.
Yes, Chairperson.
Now, any like killing that has been done or that has been caused by the police officer in the course of his or her employment would then become a subject of the IPID investigation.
That is correct, Chairperson.
That investigation, does it, in certain circumstances, end at the IPID, or the IPID investigators look at the information, make their own findings, and then transfer the matter to the NPA to consider any recommendation that would have been done by the IPID investigators?
Chairperson, the IPAD would look at that shooting incident and then analyze, make recommendations, and those recommendations, together with the report with the docket, goes to the Director of Prosecutions to make a decision to make a determination as to whether there is an offence and whether anybody can be held accountable for that shooting.
So it is correct that every killing that would have been caused by the police in the course of his or her employment as a police officer would finally end at the table, at the desk of the NPA for a determination whether to prosecute or not.
That is correct, Chairperson.
Thank you.
Thank you, Advocate Ngcukaitobi. I just want to verify a few aspects before we ask Advocate Mchweni to proceed. Look at paragraph 490 of your affidavit. It is at 1-138.
I am the Chairperson.
The second paragraph there reads, the NDPP's response, referring to Advocate Batoi, was that she was not reviewing the decision of the prosecution team, but that of Jiba and Abrahams.
That is correct, Chair.
She was responding to your disagreement with the DCOC panel's recommendation.
That is correct.
Now, as she responded in this way, doesn't that presuppose that she would have had regard to the comprehensive memoranda that you had submitted to the erstwhile NDPPs?
Ordinarily, Chairperson, when she says I'm reviewing the decision of my predecessors, the decision of her predecessors would have been based on the recommendations and the prosecution memo that we made. So ordinarily, I would have expected that to have been taken into account.
Your memoranda?
Yes, the prosecution memoranda.
Yes. My recollection of Advocate Batoi's evidence was that she never read the record, the dockets.
That is correct. I remember following that.
It seems to me that in saying so, it means she had not even had regard at that time to the summaries that had been provided by Advocate Noku.
That is correct, Chair. The summaries of the dockets that were provided by Advocate Noku.
Yes.
Yes, Chairperson.
What do you make of that?
Chairperson, you know, I was taken aback. I was just astonished as how an NDPP would act in a manner that she does, because I would have expected an NDPP to have looked at the dockets, at the summary, to have looked at the views of the DPP, because the DPP is the one who has original prosecution authority in the province. So the fact that, you know, not the summaries, not the dockets, nothing was had looked at, I found that very astonishing, particularly in the light that when Advocate Abrahams dealt with the matter, he looked at all of these things, and he even said, "Bring me the dockets," and we brought the dockets to him on a Friday, and he was, I don't know what happened, but we got the dockets back a week thereafter. But which shows that he wanted to convince himself, even from the information in the docket, that there is information linking the accused persons to the offences.
You have now had a side of the core panel's memorandum,
That is correct, Chairperson.
upon which she relied.
Yes, Chairperson.
You confirm that no mention of the dockets, or at least there are no summaries of the dockets that are the subject matter of this Katumena matter in that memorandum.
That is correct, Chairperson, yes.
Does the memorandum by the DCOC panel take into account the prosecution team memoranda that had been presented to the erstwhile NDPPs in any way?
Chairperson, I don't follow the question. Does the...
I'm asking, does this memorandum by the DCOC panel
Yes, Chairperson.
take into account, I'm sorry, does the memorandum by the DCOC panel take into account the memoranda that you had prepared, not once, not twice, if I remember, and forwarded to the erstwhile NDPPs, Advocate Nkasana, Advocate Abrahams?
Not at all, Chairperson. He doesn't take that into account.
Paragraph 484. Mention is made that Advocate Batoi assumed office on the 1st of February 2019. I think that is common cause now.
That is correct, Chairperson. I remember it was in February 2019, yes.
That is when she was now appointed as the NDPP.
That is correct, Chairperson.
That is on her return from
The Hague.
From The Hague.
That is correct, Chairperson.
At paragraph 491, the end of your affidavit, you state, on 16 July 2019, Advocate Batoi withdrew the charges against General Boysons and the other accused.
Those charges specifically are the racketeering charges that she withdrew. That is correct, Chairperson. And then she referred the balance of the charges, the predicate offences, to the DPP in KZN. I haven't met her. Advocate Harrison?
Advocate Zungu then, Advocate
yes.
Harrison?
Yes.
Correct?
That is correct, Chairperson.
Now, when you look at the the time span between January, the 1st of February 2019 and the 16th of July 2019, it gives you approximately 6 months, 2 weeks.
That is correct, Chairperson.
And the decision that was taken on the 16th of July, that decision of withdrawing the charges, followed the report of the panel, the DCOC panel,
That is correct, Chairperson.
on the 8th of July, the same year. If you look at 486. The opening paragraph sentence in
Oh, yes.
paragraph 486.
Yes, following that meeting that she convened, yes.
So she had almost 8 days,
Yes,
8 calendar days to make a final decision
that is correct.
following the presentation of that memorandum by the DCOC panel.
That is correct, Chair.
Now, if you look at the matrix, the evidential matrix that has been brought to our attention, all this evidence, the dockets, the memorandum, all the documents that have been presented to us, would it have been possible for the NDPP, given all these circumstances, to fully apply her mind, to then make a decision within that short period of time?
No, Chairperson. My view is that the period was too short for a proper analysis and for a proper applying your mind to the issues involved.
Unless, of course, she based her decision entirely on the DCOC panel memo.
Exactly.
Without
Chairperson.
more.
Without more, yes.
What is this decision? What do you make of this decision?
Chairperson, the decision is not rational. The decision is not grounded on all the facts. The decision is, in my view, with the greatest of respect, incorrect.
Can such a decision be subjected to review in terms of the law? Do you remember?
Chairperson, I would submit that it is susceptible to be reviewed.
Supposing it may not. What would then be the natural next step, proper step to take by the NDPP?
Chairperson, the NDPP can relook at this matter afresh and apply his mind properly to the matter, in my view.
If he doesn't,
Chairperson, then I would urge the family members of the deceased to to ask what is happening to this, because they still keep on asking. They must ask what is happening to these matters. Then it will prompt the national director perhaps then to revisit the decision in terms of section 1795.
I'm asking you this question because you are a lawyer. You know the mandate of this panel.
Of course,
Given
Chairperson,
the terms of reference.
I looked at the terms of reference. I have them here.
I suppose this will be a matter for argument by the parties. at the
Yes,
end
and
of,
we have
hearings.
able participants here that are whose task I will be following with envy, Chairperson.
Yes, but in the interest of justice.
In the interest of justice, Chairperson, my view is that these matters must go to court. These killings must go to court. Evidence must be presented in an open court. That is why we are in this democracy where we are, so that things must be ventilated in an open court.
And so far remedies are concerned, despite the powers that this panel has, the panel may, in the interest of justice, even consider making certain recommendations regarding this aspect.
That is correct, Chairperson, yes.
Advocate Ngcukaitobi, the documents relating to procurement in relation to item 8 of the memo, the notes, that is the outstanding documents that were listed, item 8,
Yes.
that procurement document is still outstanding?
Yes,
Your
ma'am.
juniors will look for that.
Yes.
And if they may also remember, as was the case with regard to documents that are prepared by the MPA and all the evidence leaders, such document must be properly be listed as exhibits,
Indeed.
properly
ma'am.
numbered.
Yes, thank you.
I think this will come at the end of the case of Advocate Chauke.
Yes. ma'am.
But they must start preparing so that nothing falls through the cracks.
Yes. Madam Chair, I presume with the documents they found from yesterday, they can just liaise with the researchers,
Yes,
show them where they are.
yes. I think all of you, our researchers are at our disposal to work with them and as we work together to assist you. Just check the last one. How many authorizations were granted? The racketeering authorization certificate before the assumption of office by Advocate Bartoy.
2 sets, Chairperson. The first set was granted by Advocate Jiba on the 17th of August 2012. And then the second set was the one once approved by Advocate Abrams on the 13th of February 2016.
Yes, thank you.
Thank you, Chairperson.
My sister would like.
Advocate Maema, at paragraph 490, maybe let me preface my question with this You've already dealt with the provisions of Section 1795 of the Constitution, and in particular D, where the NDPP is given a power to review a decision to prosecute or not.
That is correct, Chair.
But that refers to the decision to prosecute or not by the DPP.
That is correct, Chair.
Now, at paragraph 490, that last line, you say the NDPP's response was that she was not reviewing the decision of the prosecution team, but that of Jiba and Abrahams, meaning she is reviewing the decision of Advocate Jiba and Advocate Abrahams.
That is correct, Chair.
Was she empowered by any legislation to review the decisions of Advocates Jiba and Abrahams? And if yes, direct us to the enabling provisions, and if no, give us your reasons why you would say no.
Chairperson, I would say no, because Section 179(5) sets out the circumstances under which the National Director may exercise her review powers. And to say you are reviewing the decisions of your equals in rank National Director, it is your decision of your predecessor is your decision. How do you review your own decision? Because you're a National Director, the previous decision maker is it's functus officio insofar as you concerned. That is why at some stage I said perhaps what she could have done was to approach court to review that decision, not herself review it, because it is her own decision. It's your predecessors. You assume that decision. You assume the office.
But then, if she was not allowed to review her predecessor's decisions, how should the present NDPP now approach this matter without reviewing or without flaunting the provisions of the Constitution by revisiting this matter?
Chairperson, that is why I am more on the cautious side, because we have a constitution in this country. Rather, there should be a representation. The families of the deceased are still not happy with this. So rather, I would, even if it's a one-pager, say I'm unhappy with this decision. I want to know what happened to my relative. I want to know what happened to my dad. And can you explain to me what happened to my dad? Then in that process, then the present National Director can then relook the decision of the predecessor in line with Section 179(5)(d).
Now, Advocate Maema, reinstating these withdrawn charges, would that amount to reviewing?
Reinstating.
Remember when you testified, and even Advocate even Advocate Batohi testified that when a matter is withdrawn,
yes,
it can be reinstated
yes,
subject to further evidence being received or being
procured.
unearthed.
Yes.
So I'm asking if the present NDPP were to reinstate these charges, would that amount to reviewing his predecessor's decision to withdraw the charges, or it would be in the process of prosecution where you can withdraw and reinstate?
Chairperson, I would. There is a lot of consternation about what happened, what the Ketomena serious violent crime did, and even on the basis of the consternation that is there, in my respectful view, the present national director can revisit the decision of the predecessor. But I would be much more careful. I would say, I would, in an attempt to comply with the Constitution, I would say 1795D says, receive a representation or a complaint from a family or from some person who is not happy, and then at least you then be sure of having complied with the Constitution. Or alternatively, like I said, Chairperson, yesterday, a declaratory order. But a declaratory order, Chairperson, I hear what you say, then it would mean for every case that has been withdrawn, a prosecutor must get a declaratory order. That would be an untenable situation. But Chairperson, this is a very serious matter. It affects lots of lives in KZN, and as a national director, I will tread carefully in ensuring that I comply with the Constitution, but I also consider the sadness and all that is accompanying the families of the deceased persons in KZN.
Is there presently a law that bars the present NDPP from reinstating their withdrawn charges?
There is no law, Chairperson, not at all.
Looking at the history of this matter from 2008,
Yes, Chairperson.
or at least 2007,
Yes.
because I remember there's one docket that emanates from 2007
That is correct, Chairperson.
until today. How many years now? Approximately 10 years? Or
Close to 10 years. Not quite 10.
20
Is it 20?
years.
Oh, yes, 20.
Approximately 20 years. And in 20 years, justice has not been dispensed with regard to these matters that are still hanging in the air.
That is correct, Chairperson. It's an untenable situation. Justice served, justice done requires some promptness, and with the lapse of that period of time, a lot of injustices has happened, and it would be appreciated if it can be brought to an end.
And as we often say, we as lawyers, justice delayed is justice denied.
Denied, Chairperson, yes.
Yes, paragraph 485, that's what I was looking for earlier. You speak about you having been instructed by McAdams from the acting special director at the priority crime litigation. Is this within the NPA?
This is within the NPA.
Yes.
Chairperson, when we moved from the DPP offices, this is the unit to which we were annexed. We became part of the priority crimes litigation unit in the office of the NDPP.
And who's the head of this unit?
The head used to be Tory Pretorius, when he left, it was Chris McAdam. I do not know who the head is now. But there is a unit, priority crimes litigation unit in Advocate Batoi's office.
And evident from paragraph 485, the Katomena dockets were handed to this unit.
That is correct, Chairperson, and I have a signature of Advocate McAdams receiving the dockets, because those are important meta dockets. I had to make sure that when I leave, I hand them over to a responsible person.
It follows that all these dockets are still within the possession of the NPA itself.
That is correct, Chairperson.
Thank you, Advocate Maema. Are you done, Advocate Ngcukaitobi?
Yes, indeed, Madam Chair, I am finished.
Advocate Mchweni, before we adjourn, would you please indicate what your position is?
Madam Chair, given the fact that the panel had indicated that we'd have to adjourn at 1 o'clock, I would prefer that we start with the I wouldn't call it cross-examination, clarification exercise tomorrow.
It is always better to speak louder, sir.
I'm trying my best, Madam Chair. I'm trying my...
To the mic is dropped.
Oh.
Yes, just raise it up.
Thank you, Madam Chair.
You are an officer of court. You know in court you speak so loud, all of us. Just raise it a little bit. Yes, sir.
No, the idea was, since you indicated that we'd have to adjourn at 1 o'clock due to the commitments you have, I would suggest, subject to approval, that we start with the clarification exercise tomorrow morning. But I can assure you, we should be done by tea time or shortly after tea time. I don't have much quibble with Advocate Maema's evidence, but I just need to make sure that I gather my notes properly so that the exercise flows.
Thank you, Counsel. We will adjourn until tomorrow morning, 9 o'clock. This will afford you an opportunity to reflect on the questions that you'd like to pose to the witness, Advocate Maema. Advocate Maema, thank you very much. We were going to adjourn until tomorrow morning at 9 o'clock. You are still under oath.
That is correct,
Yes.
Chairperson. Thank you.
We adjourn.